You are listening to Based in Fact, a true crime podcast. Join host Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to season 2 of Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and this is episode 13, Notable Supreme Court Cases, Part 3. Today we'll talk about cases decided between 1995 and 2010, including Schlup, Atkins, Roper, Crawford, House, Panetti, and Martinez and Trevino. We'll look briefly at the background of each case, the issues raised by the petitioners, and the decisions of the Supreme Court. Before we start, I admit that I have missed some cases, quite a few cases, during this review. That's because I discovered some cases when they were overruled by later cases. And I also realized while I was doing my notes that I've bitten off way more than I could chew for part 3. So we will do this again during season 3. And we are, of course, open to suggestions for cases that I may not have even thought of, but you listeners may wonder about. So with that, welcome back, Kyle.
Good afternoon, Lisa. How are you?
Very well. Happy October.
Yes, it finally feels like fall here. We had a cold front blow in over the weekend, so it went from like 80 to 55. It felt like overnight.
I know. I like the weather went down from 80 to 55 like it saw a state trooper.
That's a good one. I like it.
It's a meme from Facebook and Twitter. I steal all my witty things from Facebook and Twitter. So
nice. I'm gonna have to steal that one.
All right. So we are going to wrap up our look at Supreme Court cases. We will do it again because it has been fun and interesting, but I think it's time to get back into actual cases. So, and I want to say happy birthday to one of my bosses. His birthday is today. He doesn't like to celebrate, but I told him happy birthday on Friday, but I'm going to say it again now. I don't think he listens, but he'll know if he does.
Oh, there you go. Well, happy birthday.
So, all right. So let's get started. Do you have any questions on the notes before we get started?
No, not right now. As usual, you did a very thorough job and very detailed.
All right. So one of the first cases we're going to start with, or the first case we're going to start with today, is Schlup versus DeLeo, 513 U.S. 298, decided in 1995. This case was one of an early actual innocence case. Lloyd Schlup Jr. was accused of stabbing another inmate at the Missouri State Penitentiary in Jefferson City to death with help of, I think, 2 other inmates. He denied his involvement, and at some point during his post-conviction process, he located a video that allegedly showed him in the cafeteria or the mess hall or whatever they called it at the time of the murder. So that gives you an idea. He was serving a life sentence in prison as a persistent offender for an assault in the first degree. So that's how he came to be in prison. He was convicted on December 11th, 1985, and sentenced to death for the murder of Arthur Dade. The United States Court of Appeals for the Eighth Circuit affirmed the denial of petitioner inmate's second request for federal habeas corpus relief After that denial, the inmate who had been sentenced to death filed a petition for a writ of certiorari, asserting that the courts below applied the wrong standard in evaluating his claim that constitutional error deprived the jury of critical evidence that would have established his innocence. In evaluating the inmate's petition for habeas corpus, the Intermediate Appellate Court applied the Sawyer standard and held that the inmate had failed to show by clear and convincing evidence that, but for a constitutional error, no reasonable jury would have found him guilty. In his petition for a writ of certiorari, the inmate argued that the Sawyer standard did not apply to his claim of actual innocence, and that in any event, the Intermediate Appellate Court misapplied the Sawyer standard. The U.S. Supreme Court granted the inmate's petition and held that the Carrier standard, not the more stringent Sawyer standard, governed the miscarriage of justice inquiry when a petitioner who had been sentenced to death raised a claim of actual innocence to avoid a procedural bar to the consideration of the merits of his constitutional claims. The U.S. Supreme Court held that in applying the Carrier standard in the context of the inmate's request for an evidentiary hearing, the district court should have focused on the likely behavior of the trier of fact and should have assessed the probative force of the inmate's new evidence in connection with the evidence of guilt adduced at trial. The judgment of the Intermediate Appellate Court was vacated and the case was remanded to the Intermediate Appellate Court with instructions to remand to the district court for further proceedings. So this is one of those, this is where the post-conviction claims that a reasonable jury would not have convicted, or the claims that there is, quote, reasonable doubt about guilt. This is the case that it comes from.
Oh, interesting.
So the decision was made on January 23rd, 1995, and it vacated and remanded with instructions to remand to the district court for further proceedings. The holding is quite extensive, but I am going to basically just kind of summarize. This case expanded on Sawyer versus Whitley, which we talked about, Murray versus Carrier, which is another case that we talked about, and those were both Sawyer claimed actual innocence of the death penalty, I believe, and Carrier, I can't remember what his claim was, but his claim was, I think, related to one element of the crime. So he wasn't guilty of first-degree murder, he was guilty of second-degree murder. Also, we remember Herrera versus Collins that we talked about, where he claimed that his brother's confession to multiple people undermined all the evidence of his guilt. And so this Schlup basically just expanded on all of those cases, holding that Carrier properly strikes the balance between the societal interest and the individual interest in justice when the claimed injustice is that constitutional error has resulted in the conviction of one who is actually innocent. And remember, saying you're actually innocent isn't enough. There has to be some constitutional flaw in your trial. And if I'm remembering Schlup correctly, he claimed that that video that we talked about, he claimed that was withheld. And even if it wasn't withheld, his attorneys were ineffective for not finding it. So, and finally, to satisfy Carrier's actual innocence standard, a petitioner must show that, in light of the new evidence, it is more likely than not that no reasonable juror would have found him guilty beyond a reasonable doubt. That focus on actual innocence means that a district court is not bound by the admissibility rules that would govern at trial, but may consider the probative force of relevant evidence that was either wrongly excluded or unavailable at trial. The district court must make a probabilistic determination about what reasonable, properly instructed jurors were due, and it is presumed that a reasonable juror would consider fairly all of the evidence presented and would conscientiously obey the trial court's instructions requiring proof beyond a reasonable doubt. The carrier standard, although requiring a substantial showing, is by no means equivalent to the standard governing review of insufficient evidence claims. So it distinguishes Jackson versus Virginia. In applying the carrier standard to Schlup's request for an evidentiary hearing, the district court must assess the probative force of the newly presented evidence in connection with the evidence of guilt adduced at trial. The court is not required to test the new evidence by a standard appropriate for deciding a motion for summary judgment, but may consider how the submission's timing and the affiant's likely credibility bear on the probable reliability of that evidence. And this is why we see in a lot of these cases a lot of hearsay confessions from either third-party suspects who are living or dead. And under this, if Herrera had been decided with this case or after this case, we might have seen a different outcome with Herrera.
Gotcha. That makes sense.
But the majority opinion was authored by Justice Stevens, who was joined by Justices O'Connor, Souter, Ginsburg, and Breyer. Pardon me. Justice O'Connor expressed a view in her concurrence that for purposes of showing of actual innocence required with respect to a successive or abusive federal habeas corpus petition, in light of newly discovered evidence, the Supreme Court properly balanced the dictates of justice with the need to ensure that the actual innocence exception remains only a safety valve for the extraordinary case. And two, that the Supreme Court did not need to decide whether the fundamental miscarriage of justice exception is a discretionary remedy. Chief Justice Rehnquist, joined by Justices Kennedy and Thomas, authored a dissent expressing the view that, one, for the purposes of demonstrating actual innocence with respect to a successive or abusive federal habeas corpus petition, the Sawyer versus Whitley standard should be applied to claims of guilt or innocence, as well as to a challenge to the petitioner's sentence. Two, the decision of the Court of Appeals, which had fully analyzed the accused new evidence under the Sawyer versus Whitley standard, should be affirmed. And three, if the Murray versus Carrier standard were to be adopted, then it A, should not be based on the Supreme Court's confusing explanation of that standard, and B, instead should be based on a modified version of the standard for review of the sufficiency of the evidence to meet the constitutional requirement of proof beyond a reasonable doubt, with a clearly defined area in which a district court might exercise its discretion to hold an evidentiary hearing. Justice Scalia, joined by Justice Thomas, also authored a dissent expressing the view that the case was controlled by 28 USCS 2244B, which specifically addresses the problem of second and subsequent federal habeas corpus petitions by state prisoners. The Supreme Court ought to say, as the statute did, that federal habeas corpus courts need not entertain successive or abusive petitions, and the Supreme Court ought to sustain the action of the courts below in declining to entertain the accused's second petition, for no abuse of discretion could be found in the record. The courts below were correct to use Sawyer versus Whitney as a legal standard for determining claims of actual innocence. And even if the courts below were wrong in using that standard, the judgment did not necessarily have to be reversed. So this case went back to the Eastern District of Missouri, and they basically, the court denied the inmate's motion for leave to file a first amended petition, but ordered the petition for writ of habeas corpus to be set for hearing. The court also ordered the parties to submit witness lists, exhibit lists, brief, and any depositions of witnesses. Then on May 2nd, 1996, the district court denied the superintendent's motion to vacate the court's December 8th, 1995 order, which was the one I read before. The court found the petitioner was denied effective assistance of counsel and granted the writ of habeas corpus on that basis. the court ordered the superintendent to forthwith release petitioner from custody under the death sentence imposed for his conviction of capital murder. Schlup ended up serving his life sentence, or continuing to serve his life sentence. He was not ultimately retried. In Arthur Dade's death, the authorities just let it go, as best I could determine. This is kind of at the beginning of the internet age.
Gotcha.
And so that is what happened. I mean, you know, he was serving a life sentence, so he stayed in prison. And he's another one that we probably will look at. Because he obviously it's an interesting case, and the full development of it is an interesting topic. All right. This is another case, Kyles versus Whitley, 514 U.S. 419. It was also decided in 1995. This took place in New Orleans. It's a carjacking murder case. It happened on September 20th, 1984. I happened to work with a friend of the victim and her family.
Oh, wow.
And I have a very vivid memory of this 60-plus-year-old gentleman. He was a salesman for the business that I was working for. I remember him getting the call late in the afternoon and sitting at his desk crying and unable to speak. We all thought it was his wife, one of his children, and then it turned out that it was a friend of his family.
And
terrible. Bless his heart, he apologized to everybody for making such a scene when he was able to control himself. Yeah. So this happened in Orleans Parish, Louisiana. So it was decided in the U.S. District Court, Criminal District Court. But ultimately, this decision came from the U.S. District Court and the Fifth Circuit Court of Appeals. The victim was Dolores Dye, and she was born in 1924. So she was 60 at the time of this incident. She had been at a Schwegman's grocery store in New Orleans East, I believe, or in Gentilly. And she was putting her groceries in her car. And Curtis Kyles, and I will say this, Curtis Kyles killed her. I do not believe that Curtis Kyles was ever actually innocent. I do not believe that he was ever wrongfully convicted. I believe that he was the killer, and he and his attorneys were just able to craft a good story that led to doubt in the federal courts. And we will look at his case and get into that in a little bit more detail. I think some of this we'll touch on it, but I've never believed this guy was actually innocent. It was investigated by the New Orleans Police Department. Kyles was arrested on September 24th, 1984. His first trial in November of 1984 resulted in a mistrial. His second trial was held December of 1984, and he was convicted and sentenced to death. He went through state direct appeal. He went through state post-conviction. He moved to U.S. District Court for the Eastern District of Louisiana for federal habeas corpus. He was unsuccessful at the the U.S. District Court, so he went to Fifth Circuit, and he was unsuccessful there. So, the summary of the case: petitioner challenged a first-degree murder conviction, claiming that the state failed to disclose evidence favorable to him. The Fifth Circuit Court of Appeals affirmed the denial of petitioner's habeas corpus petition, and petitioner was granted certiorari. Petitioner was convicted of first-degree murder. He appealed, claiming that the state knew of evidence favorable to him before and during trial that it failed to disclose. The state Supreme Court remanded the case for an evidentiary hearing on defendants' claims of newly discovered evidence. The trial court, after review, denied relief. The state Supreme Court denied petitioners' application for discretionary review. A petition for habeas corpus was then filed in district court, which denied the petition. The Court of Appeals affirmed by a divided vote. The Supreme Court granted certiorari and reversed and ordered a new trial, holding that the net effect of the evidence withheld by the state in this case raised a reasonable probability that its disclosure would have produced a different result. Petitioner's conviction was reversed and remanded for a new trial, ordered because the omitted evidence favoring petitioner could have potentially resulted in a different verdict. So that was a decision handed down on April 19, 1995. The holding, which is extensive, but I am going to go through every bit of it. Under United States versus Bagley, 4 aspects of materiality for Brady purposes bear emphasis. First, favorable evidence is material and constitutional error results from its suppression by the government if there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. Thus, a showing of materiality does not require demonstration by a preponderance that disclosure of the suppressed evidence would have resulted ultimately in the defendant's acquittal. And that is citing United States versus Aggers, which was distinguished. Second, Bagley materiality is not a sufficiency of evidence test. One does not show a Brady violation by demonstrating that some of the inculpatory evidence should have been excluded, but by showing that the favorable evidence could reasonably taken to put the whole case in such a different light as to undermine confidence in the verdict. And let me pause here. Basically, what this is claiming is that a person who named Kyles, who claimed to have bought Dolores Dye's stolen car from Kyles, was the real killer. And it went so far, because I remember reading this opinion years ago. It went so far as to claim that evidence from Dolores Dye found in Kyles's apartment was planted by this alternative suspect who, at some point during this post-conviction process, was murdered by members of Kyle's family.
Wait, so there was an alternative suspect and then his family killed him?
Exactly.
That is interesting to say the least.
Yeah. So, and again, this is a case that went on for 11 years, and there are multiple opinions, state court, federal court. So this is one we are going to look at, for sure. And probably sooner rather than later. All right. So, going back, third, contrary to the Fifth Circuit's assumption, once a reviewing court applying Bagley has found constitutional error, there is no need for further harmless error review, since the constitutional standard for materiality under Bagley imposes a higher burden than the harmless error standard of Brecht versus Abramson. Fourth, the state's disclosure obligation turns on the cumulative effect of all suppressed evidence favorable to the defense, not on the evidence considered item by item. Thus, the prosecutor, who alone can know what is undisclosed, must be assigned the responsibility to gauge the likely net effect of all such evidence and make disclosure when the point of reasonable probability is reached. Moreover, the responsibility remains regardless of any failure by the police to bring favorable evidence to the prosecutor's attention. To hold otherwise would amount to a serious change of course from the Brady line of cases. As the more likely reading of the Fifth Circuit's opinion shows, a series of independent materiality evaluations rather than the cumulative evaluation required by Bagley, it is questionable whether the court evaluated the significance of the undisclosed evidence in this case under the correct standard. because the net effect of the state suppressed evidence favoring Kyle's raised the reasonable probability that its disclosure would have produced a different result at trial. The conviction cannot stand, and Kyle's is entitled to a new trial. A review of the suppressed statements of eyewitnesses whose testimony identifying Kyle's as a killer was the essence of the state's case reveals that their disclosure not only would have resulted in a markedly weaker case for the prosecution and a markedly stronger one for the defense, but also would have substantially reduced or destroyed the value of the state's two best witnesses. Again, this is it's basically parsing the witnesses' words, and we see this a lot. We parse the witnesses' words. We say, well, they couldn't have meant that, or they couldn't have meant this, or they were saying left when they meant right, and that kind of, instead of taking the statements and their eventual trial testimony and using their early statements where they might have said he looks like him or it might be him. And, frankly, usually with most lineups where the suspect has been arrested, the defense attorney can witness a lineup. So if there's any, I don't know what the context of these statements were, but I'm wondering how much the defense had a chance to discover on their own. And this is one of the cases that kind of undermine the duty of the defense to undertake its own investigation. Because it basically blamed the prosecutor and the police, even for things that Kyle should have known.
Yeah, that's always interesting where you hear a lot of these where they'll argue that basically the prosecution has to be the defense too. And if they don't, then it's always, it's somehow its fault. But yeah, these seems like very basic things that even a halfway decent defense attorney could have figured out.
Similarly, a recapitulation of the suppressed statements made to the police by Beanie, who by the state's own admission was essential to its investigation and indeed made the case against Kyle's, reveals that they were replete with significant inconsistencies and affirmatively self-incriminating assertions. That Beanie was anxious to see Kyle's arrested for the murder, and that the police had a remarkably uncritical attitude toward Beanie. Disclosure would therefore have raised opportunities for the defense to attack the thoroughness and even the good faith of the investigation, and would also have allowed the defense to question the probative value of certain crucial physical evidence. Now, I can see Beanie, who was in possession of Dolores Dye's stolen car and was apparently caught in possession of Dolores Dye's stolen car, being anxious to see Curtis Kyles arrested once Beanie was pointing the finger at Curtis Kyles. And the reason is, if Curtis Kyles can shoot down a 60-year-old unarmed woman in the parking lot of a grocery store in broad daylight in front of witnesses, he's not going to hesitate to do the same thing to Beanie. While the suppression of the prosecution's list of the cars at the crime scene after the murder does not rank with the failure to disclose the other evidence herein discussed, the list would have had some value as exculpation of Kyles, whose license plate was not included thereon, and as impeachment of the prosecution's arguments to the jury that the killer left his car at the scene during the investigation and that a grainy photograph of the scene showed Kyles' car in the background. It would have also lent support to an argument that the police were irresponsible in relying on inconsistent statements made by Beanie. Well, again, this is another thing. If the police are wrong about Kyles using his own car to get to the scene, if they're wrong about where Kyles left the car, that doesn't make Kyles innocent. And where Kyles' car was at this time is something Kyles should have known, because it's his fucking car. So his defense could have said his car wasn't in that parking lot because his car was here. Because that's where he was, because he tried an alibi defense. of being in a totally different place. So again, undermining his conviction based on this is where it borders on the ridiculous. They don't need to tell Kyles where his car was.
Exactly.
And being able to show the jury that the license plate of the car wasn't recorded. Well, who's to say Kyles might not have had a different license plate on his car?
Yeah, absolutely.
Because
My guess is
I'm gonna just say it. I mean,
Yeah.
Kyles doesn't strike me as a person who's worried about driving around with the wrong license plate on his car.
right.
I mean,
Yeah, absolutely.
so,
If you're gonna murder somebody in cold blood, a little bit of switching out license plates doesn't seem like that would be that
yeah.
concerning.
And again, the state could have been totally wrong. His car could have never been in that parking lot. It was a Schwegmann's grocery store. His car could have never been in that parking lot. His car could have been in a parking lot of another business. His car could have been parked on the street. He could have gotten somebody to give him a ride to the Schwegmann's. It doesn't exonerate him. It isn't exculpatory in and of itself.
Right.
And it's funny how they criticize the Fifth Circuit for looking at each piece individually. That is when defense attorneys are looking at the case against a killer, they're looking at each piece individually and saying, well, it doesn't prove he committed this murder, so therefore it doesn't count. But when it's done in evaluating an actual innocence claim, it's wrong to do it that way.
Of course.
Okay, this one gets my blood boiling. Sorry.
Well, you've got a personal connection to it.
Although not every item of the state's case would have been directly undercut if the foregoing Brady evidence had been disclosed, it is significant that the physical evidence remaining unscathed would, by the state's own admission, hardly have amounted to overwhelming proof that Kyles was the murderer. While the inconclusiveness of that evidence does not prove Kyles' innocence, and the jury might have found the unimpeached eyewitness testimony sufficient to convict, confidence that the verdict would have been the same cannot survive a recap of the suppressed evidence and its significance for the prosecution. Justice Souter, joined by Justice Stevens, O'Connor, Ginsburg, and Breyer, authored the majority opinion. Justice Stevens authored a concurrence joined by Ginsburg and Breyer, expressing the view that even aside from the importance of the legal issue presented in the capital case at hand, the case merited review on certiorari. Justice Scalia, joined by Chief Justice Rehnquist, Justice Kennedy, and Justice Thomas, authored a dissent expressing the view that the Supreme Court had improvidently decided to review on certiorari the facts of the capital case at hand, and with respect to the accused Brady claim, the undisclosed evidence did not create a reasonable probability of a different result in light of, among other factors, the massive core of evidence which the state had presented to the jury. So on remand, Kyles was retried, or was going to be retried. He filed an appeal at the Fourth Circuit, or a writ of review at the Fourth Circuit Court of Appeal, seeking supervisory review of the order of the Criminal District Court, Orleans Parish, denying his motion to bar a fifth trial on charges of first-degree murder. I believe he was convicted of the second trial. That was vacated. He was tried a third time. That resulted in a mistrial. I think it was sometime, and then he was tried again, another mistrial as a fourth trial, if I remember correctly. Then I think the fourth trial is when Beanie was murdered. Or it may have been between the third and the fourth trial. Again, when we cover the case, I will cover Beanie's murder. So he was trying to bar a fifth trial on the charges of first-degree murder. The Louisiana Fourth Circuit Court of Appeal held, well, the summary is the defendant was tried 4 times on charges of first-degree murder, but the conviction was reversed. The judge recused himself and/or the jury was deadlocked. When a fifth trial was scheduled, defendant filed a motion to bar retrial. It had been 13 years since the first trial. The trial court denied the motion. Defendant applied for a supervisory writ of review. The court granted the supervisory writ of review and affirmed the judgment of the trial court. First, the court held that defendant did not timely file a writ of review after the issue of double jeopardy was decided adversely to him by the trial court. Further, the court held that the trial court had the inherent authority to dismiss the prosecution on the basis of fundamental fairness, but its decision not to do so was not reversible absent a gross abuse of discretion. The basis for the trial court's refusal to dismiss was that evidence of a confession purportedly made by defendant to an inmate after the first trial was unknown prior to the last two trials and was not previously presented to any jury. The trial court did not abuse its discretion in refusing to dismiss on that basis. The court granted supervisory writs of review. It affirmed the judgment of the trial court, which refused defendant's motion to bar retrial of first-degree murder charges and denied relief to the defendant. Ultimately, the fifth trial resulted in an acquittal. And that may have been because Beanie wasn't available to testify, and Kyles was successful in keeping his prior testimony out. Again, this is one we're going to look at, and unfortunately, though, there's probably not going to be any appellate or court opinions that are going to tell me what happened, because it was an acquittal and there was no appeal. However, on June 10th, 2010, Curtis Kyles committed another murder of a young woman by the name of Crystal St. Pierre. Apparently, Crystal, this happened in my neck of the woods in Algiers. Crystal apparently gave either Kyles or his girlfriend her food stamp card, and it was dead. There was no money on it. Kyles became enraged, went to the apartment where Crystal was staying, living, visiting, and took her from that apartment, took her to Avondale in Jefferson Parish, Louisiana, which was probably one of his first mistakes, and killed her and set her body on fire. He was tried from September 21st, 2015 to September 29th, 2015. He was found guilty of second-degree murder and sentenced to life without parole at hard labor. And on December 7th, 2016, his conviction and sentence were both affirmed. So that's Curtis Kyles. And again, I just don't believe, it's been a long time and I don't remember precisely the evidence, but again, I don't find the allegation that either police or Beanie planted incriminating evidence in Kyles' apartment or the apartment of a girlfriend to be particularly credible or reasonable or reliable, especially to completely go under the radar for nearly 10 years.
Yeah, well, and I mean, not that it makes him guilty, but I mean, again, he wasn't a nice little guy, minding his own business as he killed somebody else, which again doesn't make him guilty in that case, but
right,
certainly makes it seem likely.
No, I mean, like I said, they turned Beanie. This is how it happened. Beanie was caught in possession of Dolores Dye's stolen car, which he said he bought from Curtis Kyles or got from Curtis Kyles. So that's how Curtis Kyles' name came in the investigation. And interestingly enough, Curtis Kyles was not rounded up and targeted the day after Dolores Dye was murdered. He was, wasn't until Beanie was caught with the car that Curtis Kyles' name came into it. And then they started investigating and they talked to eyewitnesses, and the fact that one or two eyewitnesses may have been hesitant to identify Kyles or may not have been certain or may not have been comfortable saying that they were certain. And that's what happens too. A lot of times people are hesitant to say they're absolutely sure. And maybe because they feel like they don't want to be the one responsible for sending somebody to death row. So they're going to moderate their statements and their testimony to leave themselves out. Well, it wasn't just me. It wasn't me. But again, we'll talk about Curtis Kyles sooner rather than later, more likely than not. Although I'll probably need a 3-week period to go through everything because it is pretty extensive. All right, our next case is Apprendi versus New Jersey, and that is 530 U.S. 466. It was decided in 2000. It was a second-degree possession of a firearm for unlawful purposes, 2 counts, unlawful possession of anti-personnel bomb, and shootings, 23 counts at different dates. I guess the events involved in the case at hand occurred on December 22nd, 1994. The case occurred in Vineland, New Jersey. The victims were an African-American family. The perpetrator was defendant Charles Apprendi. He was arrested on December 22nd, 1994 in Vineland, New Jersey. He entered a guilty plea on counts 3, 18, and 22. His sentence was enhanced as a hate crime. So there was an extended term of imprisonment because what he did was basically terrorizing an African-American family that he didn't want living in his neighborhood.
Sounds like a nice guy.
Yeah, he's a real prince, let me tell you. Not. So the case came after his direct appeal. It came to U.S. Supreme Court from the Supreme Court of New Jersey. The petitioner sought a writ of certiorari to the Supreme Court of New Jersey, which affirmed petitioner's sentence under New Jersey statute annotated Section 2C 43-7A3, 2C 44-3E of the New Jersey statutes 2000, authorizing an extended term of imprisonment for hate crime. Petitioner pleaded guilty to 2 counts of second-degree possession of a firearm for an unlawful purpose and 1 count of the third-degree offense of unlawful possession of an anti-personnel bomb. The state trial court enhanced the sentence under the New Jersey statutes, finding by a preponderance of the evidence that petitioner acted with a purpose to intimidate an individual or group of individuals because of their race. The sentence was affirmed on appeal. On writ of certiorari, the court reversed the judgment because the procedure was an unacceptable departure from the jury tradition. The Due Process Clause of the U.S. Constitutional Amendment 14 required that a jury, on the basis of proof beyond a reasonable doubt, make the factual determination authorizing an increase in the maximum prison sentence. So the judgment of the state Supreme Court was reversed because it was unconstitutional to remove from the jury the assessment of facts that increased the prescribed range of penalties to which petitioner was exposed. The holding basically requires that any fact that increases the penalty for a crime beyond the prescribed statutory maximum, other than the fact of a prior conviction, must be submitted to a jury and proved beyond a reasonable doubt. And I'm not going into the the subheading holdings. Basically, if you plead guilty to a crime and the state wants to enhance your sentence because of some factor, including but not limited to that the crime you committed was a hate crime, then they have to try you before a jury and they have to prove before a jury that it was a hate crime beyond a reasonable doubt. So that is, and I think that's probably not an entirely bad thing. Because he may not have pled guilty had he known that they were going to seek an enhanced sentence.
Right. Yep. That seems reasonable.
So,
Agreed.
and you know that if you're not going to try the case, then don't try on the back end to add a factor to get a stiffer sentence. Because I think he would have, you know, I think probably his guilty plea was also based on this is the sentence, this is the maximum sentence you face. And we're pushing for the maximum sentence because what you did was really crappy. But, you know, but then they went and maybe the judge, it could have also been the judge because he's the ultimate decider. And I've seen some cases where a judge says, I know what you agreed to, but I don't agree with that. So I'm not going to sentence him to the minimum. I'm going to follow the guidelines and sentence him to the maximum. The majority opinion was authored by Justice Stevens, and he was joined by Justice Scalia, Souter, Thomas, and Ginsburg. Justice Scalia authored a concurrence, as did Justice Thomas. Justice O'Connor, joined by Chief Justice Rehnquist, Kennedy, and Justice Breyer, authored a dissent expressing the view that, among other matters, it had long recognized that not every fact that bore on a criminal defendant's punishment needed to be charged in an indictment, submitted to a jury, and proved by the government beyond a reasonable doubt. The Supreme Court marshaled virtually no authority to support the extraordinary general rule which the court announced in the case at hand. The New Jersey statutory scheme in question ought to be held constitutional, where the state scheme did not shift the burden of proof on an essential ingredient of the offense by presuming this ingredient upon proof of other elements of the offense. The magnitude of the sentence enhancement was constitutionally permissible, and the state scheme gave no impression of having been enacted to evade the constitutional requirements that attach when a state made a fact an element of the charged offense. Justice Breyer, joined by Chief Justice Rehnquist, also authored a dissent expressing the view that the impractical nature of the requirement that the Supreme Court recognized in the case at hand supported the proposition that the Constitution was not intended to embody that requirement. So this is one that's Apprendi and Ring are the two cases that are cited most frequently in death penalty litigation because they try to allege that aggravating factors weren't proven beyond a reasonable doubt, or you know that the death penalty was insufficient because of Ring or Apprendi, because of a lack of proof beyond a reasonable doubt for those things. Any questions?
No, it makes sense. I'm tracking.
Okay. All right, let's keep moving then. We're at Atkins versus Virginia, 536 U.S. 304, decided in 2002. The crime was an abduction, armed robbery, capital murder, and use of a firearm. The crime was committed. The abduction definitely occurred on August 16th, 1996, but it's unclear from the factual information that I could gather whether the crime occurred on the 16th or the 17th and murder occurred on the 16th or 17th. The case came from the Circuit Court of York County, Virginia. The victim was Eric Michael Nesbitt. The defendant was Daryl Renard Atkins, and his accomplice was William Jones. He was convicted in 1998 and sentenced to death. His direct appeal was decided on February 26, 1999, and his conviction was affirmed, but his sentence was remanded for new sentencing. He had a direct appeal after remand on September 15, 2000, at which time his sentence was affirmed by the Supreme Court of Virginia. The defendant was convicted of abduction, armed robbery, and capital murder and was sentenced to death. The Supreme Court of Virginia ordered a second sentencing hearing because the trial court had used a misleading verdict form. A jury again sentenced the defendant to death. The Supreme Court of Virginia affirmed the imposition of the death penalty the second time. In both death penalty phases, the defense relied on the conclusion of a forensic psychologist that the defendant was mildly mentally retarded. The court noted that the practice of executing mentally retarded criminals had become truly unusual and concluded that a national consensus had developed against it. Construing and applying the Eighth Amendment in the light of evolving standards of decency, the court concluded that such punishment was excessive and that the U.S. Constitution places a substantive restriction on a state's power to take the life of a mentally retarded offender. The court reasoned that the deficiencies of mentally retarded criminals do not warrant an exemption from criminal sanctions, but they do diminish their personal culpability. Mentally retarded defendants in the aggregate face a special risk of wrongful execution. The court noted that there was more disagreement about how to determine which offenders are in fact retarded than over whether or not the death penalty is appropriate for them. The court stated that it would leave to the states the task of developing appropriate ways to enforce the constitutional restriction upon its execution of sentences. So the judgment was reversed and the case was remanded for further proceedings not inconsistent with the opinion. And basically, again, I'm just going to go in the main holding was that execution of mentally retarded criminals is cruel and unusual punishment prohibited by the Eighth Amendment. And the court goes into a lot of sociological and psychological and morality justifications for this holding. I don't necessarily agree with them. And one of the reasons I don't necessarily agree with them is because look at Richard Glossop. After years of post-conviction litigation, suddenly, when he's facing execution in 2022, what does he do? He says he's mentally retarded. He has an IQ below room temperature and therefore is not eligible to be executed. So I think that Atkins, I'm not saying that Atkins is not mentally retarded or was not mentally retarded, but he also had enough wherewithal to engage in a kidnapping and murder of a person from a location and hiding the body and covering up the crime and lying about the crime. I mean,
yeah, that's where I always struggle with these is yes, it feels kind of creepy, but again, you say they may be, mentally retarded, but they just may be that they're functional. They're smart enough to know, like you said, how to hide a body, how to try to conceal a crime. It's not like they're truly naive and didn't think they were doing anything wrong. They knew exactly what
and they know
wrong.
right from wrong. That's the
Exactly.
thing. And
exactly.
Another thing, like I've always said, I don't think, like Jesse Miskelly's capacity for intellectual capacity, I don't think his is so much an organic problem as basically a lack of drive or a lack of interest.
Yeah, exactly.
So he's not going to do well in school. But
that's right.
Somebody not doing well in school doesn't necessarily mean that they're mentally retarded.
Right, exactly.
When we moved from Houston to New Orleans, I didn't do well in school. But even at that age, I had a higher than average IQ. But I wasn't applying myself. Because in my little adolescent brain, I decided I didn't want to leave Houston. I don't like this school. I'm not going to do the work.
Right.
It was a conscious decision on my part. And then when I got grounded forever until my grades came up. Then I started a pattern, and I will admit this, of doing just enough to get by, just enough to pass. Or in classes that I really, really liked, just enough to get a high grade. And it wasn't until I was in junior high school that I started seeing the only person being hurt by this bullshit is you. And then in high school, I realized you really screwed yourself over, because now colleges are not after you. And they're not going to be after you because you have not demonstrated that in spite of your high IQ, you also know how to do the work. In fact, you've given the, impression that in spite of your high IQ, you're very lazy. And that's all on me. That's nobody's fault. It's not my parents' fault. It's not school's fault. It's not teacher's fault. That's me. Because I recognize that's how I did it. And by the time I realized how wrong it was, I didn't know what I was doing. I didn't know how to study. I didn't know how to do the work because I'd never done it before. And it wasn't until I was in college that I really began to know how to apply myself. But I've never taken the easy way out since. So.
Yeah. Oh, yeah. Like you said, though, it makes me, having not being very book smart or not even having a high IQ, you still know right and wrong. It's not like somebody has no idea, because they function within the bounds of society and what's right and wrong.
Mm-hmm.
And much of the other part of their life, except when they're committing this crime. So they clearly know the difference between right and wrong. It's an easy cop out, I think.
Totally agree. All right. So the majority opinion was authored by Justice Stevens. He was joined by Justices O'Connor, Kennedy, Souter, Ginsburg, and Breyer. The Chief Justice Rehnquist authored a dissent. He was joined by Justices Scalia and Thomas, expressing the view that the work product of legislatures and sentencing jury determinations ought to be the sole indicators of which courts ascertain the contemporary American conceptions of decency for purposes of the Eighth Amendment. The Supreme Court erred in giving weight to foreign laws, to views of professional and religious organizations, and opinion polls. Even if some opinion polls were to be used, the Supreme Court lacked sufficient information to conclude that the polls cited by the court, A, had been conducted in accordance with generally accepted scientific principles, and B, were capable of supporting valid empirical references. Justice Scalia, joined by Chief Justice Rehnquist and Justice Thomas, also authored a dissent expressing the view that the execution of offenders who were mildly mentally retarded would not have been considered cruel and unusual punishment when the Eighth Amendment was adopted. The factor that 18 states, which were less than half the number that permitted capital punishment, had recently enacted legislation barring the execution of criminals who were mentally retarded was not sufficient to establish a national consensus, especially since only 7 of those states had barred all such executions. Some other factors referred to by the Supreme Court, such as the short-term trend toward barring such executions, the margins by which legislatures had enacted such bans, the supposed infrequency of such executions in states which still allowed them, the views of professional and religious organizations, public opinion polls, and the practices of other countries were irrelevant to establishing a national consensus. And kind of goes along those same lines. And in this particular review, normally dissents don't really mean anything in the normal course of things. But since we're going to talk about the holdings, I think it's also important to talk about the members of the court who didn't agree with the holding, whether it's like this one where they don't agree with the court's holding as the execution of mentally retarded individuals, or whether it's a later case where they don't agree with the fact that maybe the court didn't expand Brady in the way that the more liberal members of the court thought it should be expanded. And I think we'll get to a couple of those a little bit later. And we probably have seen a couple of those, you know, in our prior reviews. So again, I know dissents aren't controlling, but I think they're enlightening in this context. So on June 8, 2006, Atkins had been sent back to state court, and he was resentenced. Defendant was, or no, he was actually retried, apparently. He was convicted inter alia of capital murder. Both the original jury and a subsequent jury on remand sentenced defendant to the death penalty. After the case was remanded a second time for a determination of whether defendant was mentally retarded, a third jury found that defendant was not mentally retarded, and the Circuit Court of York County, Virginia, reinstated the death penalty. Defendant appealed. Defendant argued that a clinical psychologist appointed to evaluate defendant concerning the existence or absence of mental retardation was not qualified to testify as an expert because the psychologist did not meet the requirements of Virginia Code annotated 19.2-264. I'm not going to read the whole statute. And did not conduct the evaluation in accordance with the provisions of Virginia Code. And the Supreme Court concluded that the Circuit Court abused its discretion in allowing the psychologist to testify and express an opinion about whether the defendant was mentally retarded because the Commonwealth failed to establish that the psychologist possessed the necessary qualifications. In addition, the error was not harmless because there was no way to determine how much weight the jury placed on the psychologist's testimony. So the judgment of the Circuit Court was reversed, and the case was remanded yet again for a new proceeding to determine whether the defendant was mentally retarded. Again, June 4th, 2009, another direct appeal. The defendant had been sentenced to death, but the case was remanded to the Virginia trial court for it to determine whether he was mentally retarded. The trial court set aside the death sentence and imposed a sentence of life imprisonment without the possibility of parole based on newly discovered evidence of a Brady violation. The Commonwealth petitioned for a writ of mandamus and a writ of prohibition. Defendant's accomplice testified that defendant was the triggerman. After remand, defendant filed a motion requesting the imposition of a life sentence or a new trial on grounds the Commonwealth withheld exculpatory evidence and suborned perjury during his murder trial. In setting aside the death sentence, the trial court found that the prosecutor had coached the accomplice, which caused him to change his story. The High Court held that the Commonwealth could not use mandamus to collaterally attack a final judgment entered by a trial at the conclusion of a criminal case. That the High Court's mandate related solely to the issue of mental retardation did not divest the trial court of jurisdiction to consider other legal issues the party raised on remand, including defendant's motion. Mandamus could not be used as a substitute or an appeal in a criminal case because the Commonwealth's appellate rights were strictly prescribed by the Virginia Constitution and Virginia Code. The trial court had entered a final judgment. A petition for a writ of prohibition could not be used to vacate or undo that final judgment. The High Court dismissed the Commonwealth's petition for writ of mandamus and petition for writ of prohibition. So that one's kind of because the state couldn't appeal that final judgment, so they tried alternative means of having it reviewed, which were not proper. So in the end, Atkins was sentenced to life in prison. All right, Ring versus Arizona. This is another sentencing case. It was 536 U.S. 584, decided in 2002. The case was a robbery and murder which occurred on November 26, 1994. It occurred in Glendale, Maricopa County, Arizona. The victim was John McGotch. The defendant was Timothy Stewart Ring. The accomplices were James Greenham and William Ferguson. Ring was arrested on February 16, 1995 in Glendale, Arizona. He was convicted of felony murder in November of 1996. He was sentenced on October 29, 1997 by special verdict by a judge to death. At that time, if I recall correctly, and I may be not recalling correctly, that's entirely possible. Arizona did not necessarily use a jury to impose a death sentence. And we'll have to look at that case for the exact procedure. And they'd been doing it for years and nobody had ever challenged it until Mr. Ring. So obviously his sentence and conviction were upheld on direct appeal, and the writ was taken from the Supreme Court of Arizona to the U.S. Supreme Court. Petitioners sought a writ of certiorari to the Arizona Supreme Court, challenging the holding that his death sentence for murder and other crimes was consistent with the Sixth Amendment. The United States Supreme Court granted the petition for a writ of certiorari to allay uncertainty in lower courts caused by the manifest tension between Walton versus Arizona and the Apprendi case, which Walton was decided in 1990. This is one of those cases that I missed. The question presented was whether an aggravating factor may be found by the judge as Arizona law specified, or whether the Sixth Amendment's jury trial guarantee made applicable to the states by the 14th Amendment required that the aggravating factor determination be entrusted to the jury. The court concluded that the Walton decision and the Apprendi rule were irreconcilable because there was no specific reason for accepting capital defendants from the constitutional protections extended to defendants generally. Because Arizona's enumerated aggravating factors operated as the functional equivalent of an element of a greater offense, the Sixth Amendment required that they be found by a jury. The court overruled Walton to the extent that it allowed a sentencing judge sitting without a jury to find an aggravating circumstance necessary for the imposition of the death penalty. The judgment of the Arizona Supreme Court was reversed and the case was remanded for further proceedings. So on June 24, 2002, Ring's case was reversed and remanded. Again, extensive holdings, but it's pretty much that Walton and Apprendi were irreconcilable, and the court's Sixth Amendment jurisprudence cannot be home to both. Accordingly, they overruled Walton to the extent that it allowed a sentencing judge sitting without a jury to find an aggravating circumstance. And I think that's pretty much that's the holding. And they, the sub holdings kind of explain all of the rationale, similar to the rationale from Apprendi,
Right.
that basically aggravating circumstances can elevate the crime or the punishment, and therefore they need to be proven to a jury beyond a reasonable doubt.
That makes sense.
So the majority opinion was authored by Justice Ginsburg, who was joined by Justices Stevens, Scalia, Kennedy, Souter, and Thomas. Justice Scalia authored a concurrence, which was joined by Justice Thomas, and I'm not going to go into that. Justice Kennedy also authored a concurrence, which and kind of a concurrence in part and a dissent in part. He felt that Apprendi had been wrongly decided, even though that was the case. It was the law, and no principled reading of Apprendi would allow Walton to stand. So he had disagreed with Apprendi. My mistake. Breyer also concurred in the judgment and authored a concurring opinion. Justice O'Connor, joined by Chief Justice Rehnquist, authored a dissent expressing the view that Apprendi versus New Jersey had been wrongly decided, and that it, rather than Walton versus Arizona, ought to be overruled. So the Walton was overruled. Ring went back to the trial court, went back to state court. He was convicted of murder and sentenced to death. His death sentence was automatically reviewed, and the only issue on appeal was whether reversible error occurred when a trial judge sentenced defendant to death under a procedure that violated the right to a jury trial under the Sixth Amendment of the United States Constitution. Defendant was convicted of being the shooter in the murder and robbery of an armored truck official. The state argued that a sentence of death was proper as defendant committed the murder for pecuniary gain. The basis for the finding that the murder was committed for pecuniary gain was the testimony of a co-defendant who testified that defendant was the ringleader in the assault, was the shooter, and the money stolen from the truck was placed in defendant's truck. On cross-examination, however, the co-defendant admitted that he had previously told police that he was the shooter and admitted that his testimony was payback against defendant because defendant threatened his life and interfered with the co-defendant's relationship with his ex-wife. The state Supreme Court vacated the death sentence because the trial judge's finding of the pecuniary gain aggravating factor rested on the co-defendant's credibility, and a reasonable jury could question the co-defendant's veracity, and concluded that the state had not met its burden of establishing that aggravated factor beyond a reasonable doubt. So his death sentence was vacated and he was resentenced. It was remanded for resentencing, which was done on July 17, 2007. He was sentenced to natural life pursuant to the agreement between Ring and the state, meaning that he will serve his life in prison. And without possibility of parole. All right. Any questions? Comments? Thoughts?
No, I mean, it's a lot. I think that I was just thinking it's it's interesting just when you see the mix of the majority opinion. Not many cases you see that group together, so it was kind of an interesting
yeah,
selection.
I thought that was pretty interesting too. Especially when Justice Scalia took a lot of heat from anti-death penalty, liberal-minded individuals, and Justice Thomas continues to take a lot of heat from that same group. And
Right.
yeah, the fact that they concurred. I always liked Justice O'Connor because she was truly kind of a middle of the road.
Yeah.
Sometimes she was on the kind of liberal side, which to me says this was a principled holding and not a social
right
holding. But sometimes she was also the author of a lot of dissents.
Right. That makes sense.
All right. So next case, Crawford versus Washington, 541 U.S. 36, decided in 2004. The crime occurred on August 5th, 1999. It was a first-degree assault while armed with a deadly weapon and attempted first-degree murder while armed with a deadly weapon. It occurred in Olympia, Washington. The victim was Reuben Richard Kenneth Lee. The defendant was Michael Crawford. He was arrested on August 5th, 1999 in Olympia, Washington. I don't know anything about his trial. I had a little hiccup that I could not overcome. He had a direct appeal to the Washington Court of Appeals, which reversed his conviction. And then the Washington Supreme Court reinstated the conviction. And it's also important to note is his wife gave statements that were inculpatory to Michael to police and that undermined his claims of self-defense. Basically, what happened was the wife allegedly told Michael that Lee attempted to sexually assault her. Crawford got mad and there was an altercation with Lee. That was the initial story that they both told police. But later, she admitted that the attempted sexual assault actually occurred sometime before August 5th, and that she brought Michael to Lee's apartment for Michael to confront him. And that's when the assault and stabbing and altercation came. So that's where it is. But then at trial, what did Michael do? Michael invoked the spousal privilege. So his wife could not be called or compelled to testify against him. To me,
is that so the defendant gets to invoke that? Like if the wife wanted to testify, the defendant can still prevent her or him from doing it. Okay, got it.
Just
I understood it was they couldn't compel you, but if you still wanted to, you could. But if the defendant can basically prevent you from doing that.
The defendant can prevent you. You can, like a priest, you can't compel a priest to testify.
Right.
And either the priest can invoke that or the penitent can invoke that.
Gotcha.
And in this case, a wife can't be compelled to testify against her husband. And even if she wants to, he can invoke that to prevent her to testify. Now, to me, in equity and fairness, if you're going to keep her from testifying and you can't confront her, that should be on you. If her statements to police, which were given with Miranda and were recorded and entirely above board, are going to be admitted. In that case, you should withdraw and let her testify and cross-examine her. But anyway, that's not what happened. So defendant was convicted in state court of assault, but asserted that the admission of his wife's statement to police after defendant invoked state marital privilege to preclude her testimony at trial violated defendant's constitutional right to confront witnesses against him. Upon the grant of certiorari, a writ of certiorari, defendant appealed the judgment of the Supreme Court of Washington, which upheld the conviction. The state asserted that United States Supreme Court precedents allowed the use of the wife's statement, which arguably controverted defendant's assertion of self-defense, since the wife was unavailable as a trial witness due to marital privilege, and her statement to an interrogating police officer had sufficient indicia of reliability. The Supreme Court held, however, that the prior case law erroneously permitted admission of the wife's statement based on the amorphous concept of reliability without taking into account the constitutional requirement of confrontation that the statement be subject to cross-examination. The wife's statement during interrogation was testimonial in nature rather than non-testimonial hearsay, which would be properly subject to evidentiary rules concerning reliability, and defendant's right to confront the wife thus clearly included the right to cross-examine the statement, especially in view of the ambiguity in the statement. The right to confrontation was not a substantive guarantee that evidence be reliable, but rather a procedural guarantee that the reliability of the wife's statement be tested by cross-examination. The judgment upholding defendant's conviction was reversed, and the case was remanded for further proceedings. Now, again, one of the reasons I disagree with this is this would allow a defendant to, in essence, mislead the jury by giving an account that he knows to be false, because he knows his wife has already told police it didn't happen that day. It happened a week before, or 2 days before, or 10 days before. So I disagree entirely with this. The state's use of Sylvia's statement violated the Confrontation Clause because where testimonial statements are at issue, the only indicium of reliability sufficient to satisfy constitutional demands is confrontation. And then the subholdings basically go through the confrontation clause, and refer to a case, Ohio versus Roberts, which will be one that we will include on our next Supreme Court review.
Gotcha.
It's one I didn't even think of or consider until it was overruled in Crawford. So, and basically this one I really disagree with, again, because I think it allows a defendant who's keeping a witness from testifying to mislead the jury. Now, if the defendant has nothing to do with the witnesses being unavailable, or if the witness simply refuses to appear, refuses to show up, then that's another story. But in this case, Crawford had gotten her testimony excluded by asserting spousal privilege.
Yeah, I agree with you. It seems a little bit of bridge too far.
And so basically they're saying, yeah, he can go ahead and mislead the jury and say, the attempted rape happened that night, and he was just reacting to that. Justice Scalia authored the opinion of the court, majority opinion. He was joined by Justices Stevens, Kennedy, Souter, Thomas, Ginsburg, and Breyer. Chief Justice Rehnquist, joined by Justice O'Connor, concurred in part, but they also he authored a dissent joined by Justice O'Connor, expressing the view that in the case at hand, the judgment followed inexorably from Ohio versus Roberts and its progeny without any need for overruling that line of cases, and that Ohio versus Roberts should not be overruled. So Ohio versus Roberts was overruled. And I couldn't really find out what happened, whether he was retried or whether he entered a plea, or what really happened after that. Unfortunately, whoever authored the Wikipedia article was also similarly unsuccessful in finding out what happened, or whether, by the time it made its way through the Supreme Court, whether his sentence had expired. I'm sure he was probably in prison during that time, and an assault generally, unless you're a persistent offender, a career criminal, or 3 strikes, you're out, criminal, you're not going to serve life for an assault, even with a deadly weapon that doesn't result in death. All right, our next case is Roper versus Simmons. It arises from a murder that occurred on September 8th, 1993. It also came out of the Circuit Court of Jefferson County, Missouri. Events in the case happened in St. Louis County, Missouri. The victim was Shirley Crook. The defendant was Christopher Lee Simmons. And his accomplice in the crime was Charlie Benjamin. Christopher Lee and Charlie were both minors. Christopher was arrested on September 10th, 1993 in Fenton, Jefferson County, Missouri. He was convicted at trial and sentenced to death. His direct appeal, he sought review of his conviction for first-degree murder and his death sentence in the Circuit Court of Jefferson County, Missouri. He argued that the Fifth Amendment rights were violated when he was subjected to interrogation, despite his announcement of his right to intent to remain silent, and that his confession was coerced, and that the prosecutor made improper remarks during closing, and that his counsel was ineffective. He was convicted of first-degree murder and sentenced to death. Sought review of the conviction and sentence, arguing again that his confession was involuntary and coerced. The court affirmed the conviction and the death sentence, holding that a suspect in custody was required to give a clear, consistent expression of his desire to remain silent in order to evoke his Miranda rights adequately and cut off questioning. The court stated that there was no testimony that indicated the defendant invoked his right to remain silent because defendant received and understood his Miranda warnings. He was aware of the right to stop questioning at any time. The court further held that defendant's confession was admissible. Officer's statements to a suspect that cooperating was in his best interest were not coercive and did not render a confession involuntary. So his conviction and sentence were both affirmed by the state Supreme Court. He filed a habeas corpus challenge. And the reason I went into this case with the underlying claims is because he never really brought up his age as a factor precluding his death sentence. So his federal habeas corpus was decided and in 2003. He murdered the victim because of a prior United States Supreme Court decision. Defendant did not argue that his age constituted a bar to imposition of the death penalty. He was convicted and sentenced to death. The state Supreme Court affirmed his conviction and death sentence, as well as the denial of post-conviction relief. Subsequently, the United States Supreme Court held that a national consensus had emerged against the execution of mentally retarded offenders. Defendant then asked the state Supreme Court to hold that a similar consensus against the execution of juveniles had developed, that the rationale for the United States Supreme Court's determination that the execution of juveniles was not cruel and unusual punishment disappeared, and that the Eighth Amendment barred his execution. The state Supreme Court found that in the 14 years since the prior case was decided, a national consensus had developed against the execution of juvenile offenders. Thus, the state Supreme Court found that the United States Supreme Court would today hold that juvenile executions were prohibited by the 8th and 14th Amendments. So the state Supreme Court set aside the death sentence. So Roper is the warden, and Roper is the one who appealed the state Supreme Court's decision. And that was actually state post-conviction, not federal post-conviction. My apologies.
Yeah, I always laugh when the wardens are in these cases. I mean, I know they are. I just think it's kind of funny.
Yeah. What was I going to say? I thought of something else. Oh, one of the things that I have always thought is so wrong about the juvenile argument is by the time you execute them, they are no longer a juvenile. You're not executing a 16 or 17-year-old kid because you're not taking them out behind the courthouse and putting a bullet in the back of their head the day they're convicted. You're executing a grown person who at 15, 16, 17 committed a brutal, heinous murder. I mean, Shirley Crook, this was not, a burglary gone wrong or an accident. They went there with the intent to kill somebody. And they kidnapped her and took her to a bridge in St. Louis County, tied her hands and feet, and threw her off the bridge to drown. Okay, this was as cold-blooded as you can get. And it's not like she was a teacher that gave them both Fs.
Yeah, that's what I was going to ask. Did they have a particular beef with her, or were they just looking for anybody?
They were just looking for somebody to kill. Like gotcha. Damien Eccles. They were just looking for somebody to kill. It didn't matter who.
Gotcha.
So,
yeah, the juvenile argument too, I've always had issues with. I mean, it sounds bad emotionally, but then you realize, some of these horrible crimes that juveniles have committed.
Yeah. So, all right. And this one, this is another one we're going to look at because the dissents in this one were really, really, really powerful as a whole. And the summary that I'm going to read is probably not going to do them justice. But it seems like Simmons is the one that had some really good ones. So the case summary: respondent juvenile committed murder at the age of 17. So they were 17. They weren't 15. He was tried and sentenced to death. He filed a petition for state post-conviction relief, arguing that the reasoning forbidding the execution of mentally retarded persons established that the Eighth Amendment was also prohibited the execution of a juvenile who was under 18 when the crime was committed. The Missouri Supreme Court agreed. Certiorari was granted. The court began with a review of objective indicia of consensus on juvenile capital punishment as expressed by the enactments of legislatures that had addressed the question. 30 states had prohibited the juvenile death penalty, 12 that had rejected the death penalty altogether, and 18 that had maintained it, but by express provision or judicial interpretation, excluded juveniles from its reach. The court noted that even in the 20 states without a formal prohibition of executing juveniles, the practice was infrequent. Again, you're not executing a juvenile. By the time they're executed, they're grown. The court held that this provided sufficient evidence that American society viewed juveniles as categorically less culpable than the average criminal, and went on to provide 3 reasons. The lack of maturity and an underdeveloped sense of responsibility were found in youth more often than in adults, and were more understandable among the young. Juveniles were more vulnerable or susceptible to negative influences and outside pressures, including peer pressure, and the character of a juvenile was not as well formed as that of an adult. The court held that the Eighth Amendment forbids the imposition of the death penalty on juvenile offenders under 18. The judgment setting aside the sentence of death imposed upon the respondent was affirmed. So on March 1st, 2005, this was affirmed. Again, I'm not going to go through the holding. Basically, the 8th and 14th Amendment forbid imposition of the death penalty on offenders who were under the age of 18 when their crimes were committed, because the holdings, again, are just rationale.
Well, I think it's really, I think those positions are really illogical, because you're arguing that a juvenile or even somebody who is mentally retarded doesn't know what they're doing, so they shouldn't get the death penalty. But the logic should be, well, then they just shouldn't be held accountable. Like, if a juvenile's brain is underdeveloped and they don't know they're committing crime, then they shouldn't even be in prison. Like, if you take their argument, that's what they're arguing. 2 different things, right?
Yeah.
They're saying, oh, juveniles' brains aren't formulated,
Right.
and so they shouldn't get the death penalty. Well, by that logic, they shouldn't even be imprisoned or held accountable at all, based on the argument they're making.
Right. And in this case, if I remember correctly, there was a 3rd juvenile who refused to go along with Benjamin and Lee, or Benjamin and Simmons. And in this case, from what I read, the only one subjected to peer pressure was Benjamin, because this was all Simmons's idea. So yeah, and again, I mean, you can read the holding because you've got the notes. I mean, it's just a lot of sociological mumbo jumbo about something that the magical age of 18.
Yeah, exactly.
Once you're 18, you're shit out of luck, dude.
Yeah. Yeah, because, and I mean, I think it's a good point, because even with that brain formation argument, I think the general consensus is now, I mean, it's probably your early 20s before your brain is fully, where you're really, making better decisions. So again, if that's the argument you're going to make, take it up to 25.
And the anti-death penalty bar has argued that people who were 18, 19, 20 should be executed because of their youth at the time they committed their crimes, trying to expand Simmons. And if the court, if the liberals are successful in adding additional justices to the court, and the court becomes as liberal as they want it to be, they will probably succeed. And pretty soon, anybody who commits a crime under the age of 40 won't be eligible for the death penalty.
Oh, absolutely.
And anybody who commits a crime over the age of 45 won't be eligible for the death penalty.
Right.
Because they'll have some reason why when you're over the age of 45,
Exactly.
you're just a cranky old bastard and you're bound to kill the first person that aggravates you just enough.
You're not wrong. That's pretty funny.
Yeah, I probably shouldn't joke, but sometimes I have to do something to make myself laugh. And hopefully make others laugh. And I don't mean to make light of it. I don't do it to make light of it. I simply do it because the weight of the frustration is so great that I'm going to become too angry to engage in reason discussion.
Well, I just wish, I mean, if you oppose the death penalty, fine. I wish they would just say, we don't like the death penalty, rather than all of the kind of horseshit arguments. You know, just say we don't like it. Like, okay, that is a fine position.
Correct. All right. So the majority opinion was authored by Justice Kennedy. He was joined by Justice Stevens, Souter, Ginsburg, and Breyer. Justice Stevens also authored a concurrence joined by Justice Ginsburg. There were two dissents. One was Justice O'Connor expressing the view that the court's decision was not justified by the objective evidence of contemporary societal values, the court's moral proportionality analysis, or the two in tandem. The evidence before the court failed to demonstrate conclusively that any national consensus against capital punishment of 17-year-old offenders had emerged in the brief period since the court had upheld the constitutionality of this practice in Stanford, another case I missed.
Well, and I didn't get on my soapbox earlier, but we have the court, so it doesn't just reflect the will of the masses. That's why we have the executive branch and the legislative branch. I mean, the court should interpret the law and rule objectively, not on whatever's popular at the moment. That's the whole point of having that protection. So that really irritates me when they try to act as a legislature and not a court.
And it's called legislating from the bench.
Absolutely.
All right. Back to the court had adduced no evidence impeaching the seemingly reasonable conclusion reached by many state legislatures that at least some 17-year-old murders were sufficiently mature to deserve the death penalty in an appropriate case, and it had not been shown that capital sentencing juries were incapable of accurately assessing a youthful defendant's maturity or of giving due weight to the mitigating characteristics associated with youth. Justice Scalia also authored a dissent joined by Chief Justice Rehnquist and Justice Thomas, expressing the view that the court had A, proclaimed itself sole arbiter of the nation's moral standards, and B, in the course of discharging that responsibility, had purported to take guidance from the views of foreign courts and legislatures. 2, the meaning of the Eighth Amendment, no more than the meaning of other provisions of the Constitution, ought not to be determined by the subjective views of A, 5 members of the Supreme Court, and B, like-minded foreigners. So Stanford versus Kentucky was overruled. That was 492 U.S. 361, 1989. Again, when we do this again, I will probably take one episode and go through these early cases that I didn't address, and then B, pick up where I'm leaving off tonight or today. All right, our next case is House versus Bell, 547 U.S. 518, and it was decided in 2006. The crime was a first-degree murder, which included rape, committed on July 14th, 1985. It occurred in Union County, Tennessee. The victim was 29-year-old Carolyn Muncie. The defendant was Paul Gregory House. He also had a criminal history and was on parole at the time from Utah for an aggravated sexual assault. He was arrested on July 17, 1985 by the Tennessee Bureau of Investigation. And the case, this is after state direct appeal, state post-conviction, and I believe 1 or 2 successive state post-conviction claims and a federal habeas claim, and this was actually, I believe, a successive federal habeas claim. Petitioner prison inmate who was convicted in state court of murder and sentenced to death asserted that new evidence indicated that he was actually innocent of the crime. Upon the grant of a writ of certiorari, the inmate challenged the judgment of the U.S. Court of Appeals for the Sixth Circuit, which affirmed a denial of habeas corpus relief on the ground that the inmate failed to show actual innocence to preclude procedural default. The inmate's constitutional claims were barred based on state procedural rules, but the inmate contended that evidence of his actual innocence was sufficient to accept his claims from procedural default. The inmate asserted that new evidence conclusively established that semen on the victim's clothes was that of the victim's husband and indicated that bloodstains on his clothes resulted from spillage from samples of the victim's blood and that the victim's husband was the likely murderer. Now, I'm going to pause here because this is the biggest load of bull I've ever seen. They apparently, when they did the testing, and this is another case we're going to look at a little bit more in depth because it did involve DNA testing, either the results of swabs were inconclusive or results of swabs returned no DNA. The only DNA was from the nightgown that the victim was wearing when her body was found. That her husband's semen might be on that nightgown unrelated to her murder is not outside the realm of possibility. They also had alleged confessions of her husband, who was alive and well and never testified that he was the real killer. So they were using hearsay admissions from the husband as evidence that he was the real killer. Also, the claim that the victim's blood on House's pants came from contamination during transport was something that, because I read extensively about this case when it was happening in 2006, came from somebody admitting that the pants and the blood sample were transported together, and so contamination could have occurred. Not that it did, but that it could have occurred. Now, you also have to go back, and House, at the time of the crime, claimed the blood on his pants was his own because he was jumped by people. Because he disappeared for several hours during the window that the crime was committed. And he claimed a white truck stopped next to him. He was walking around, white truck stopped next to him, and some guys got out and beat him up, and the blood was his. Well, it turned out to be the victim's blood on his pants. Not his own, the victim's. So, I think all the exculpatory evidence that they relied upon was not strong, and they didn't take all the evidence against him at his trial. They didn't take any of that into account. They merely declared that this exculpatory he's probably not guilty. The U.S. Supreme Court held that while there was no showing of conclusive exoneration, consideration of the inmate's claims was warranted despite procedural default, since it was more likely than not that no reasonable juror viewing the record as a whole would lack reasonable doubt. Although sexual assault was not an element of the offense, the semen evidence was used to infer the inmate's motive and to support the death penalty, and the only other forensic evidence, the bloodstains, was shown to be of questionable origin. Further testimony that the husband confessed and evidence that the alcoholic husband regularly abused the victim potentially indicated the husband as a murderer. The judgment upholding the denial of habeas corpus relief was reversed, and the case was remanded for consideration of the inmate's procedurally barred claims. So reversed and remanded. Again, I'm not going to go into it's a long and detailed holding, and when we talk about the case, we'll end up talking about it, I'm sure. So I'm just going to go ahead and skip to the opinion. The majority opinion was authored by Justice Kennedy, who was joined by Justice Stevens, Souter, Ginsburg, and Breyer. There was a concurrence in part and a dissent in part authored by Justice Roberts, who was joined by Justice Scalia and Justice Thomas. Essentially, they agreed with the majority in the instant case that the accused had not met the threshold of a freestanding innocence claim, assuming that such claim existence. But they also expressed the view that the question was not whether the accused was prejudiced at his trial because the jurors were not aware of the new evidence, but whether all the evidence considered together proved that the accused was actually innocent, so that no reasonable juror who was aware of all that evidence would vote to convict him. Considering all the evidence and giving due regard to the district court's findings on whether the accused's new evidence was reliable, it was not probable that no such reasonable juror would vote to convict him. And Justice Alito took no part in the consideration or decision in this case. That may have been because he had just been appointed to the court. It may have been because he had some part at this, 8th Circuit Court of Appeals or the 6th Circuit Court of Appeals. I can't remember which circuit. I think Tennessee's in the 6th Circuit. So that's House. We will look at House most definitely. House was released from prison in 2008. He was suffering for many years with MS. He was released from prison after objection by the district attorney. And then the state, because of the time that had passed from the murder, elected not to retry him. So that is House. The next case, again, this is another one that I totally disagree with the U.S. Supreme Court on. Surprise. Panetti versus Quarterman, 551 U.S. 930, decided in 2007. This crime occurred on September 8th, 1992. It was a capital murder, 2 counts, and a kidnapping, 2 counts. The case came out of the 216th District Court in Gillespie County, Texas, and was also heard by the U.S. District Court, Western District of Texas. The victims in the murder were Joe and Amanda Alvarado, who were Scott Panetti's mother and father-in-law. The victims in the kidnapping were his wife and 3-year-old daughter. The defendant is Scott Louis Panetti. He was arrested on September 8th, 1992 by Texas Rangers in Gillespie County. He was tried September 12th, 1995 to September 21st, 1995, and sentenced to death on September 22nd, 1995. This case to the U.S. Supreme Court was reviewing a decision by the 5th Circuit Court of Appeals. Now, apparently, the 3-year delay between his arrest and his trial was because Scott played the mentally competent card and for a time was held to be incompetent to stand trial and then was found to be competent. And there's apparently conflicting evidence as to whether he is or is not competent because there are, this is another case we're going to look at, because there are apparently recordings with Scott talking to his parents in which he says things like, oh, was that our psychiatrist? Okay, yeah, I acted for him. I acted the way I should act. Was that state psychiatrist? I didn't cooperate with him. So you got to wonder whether Panetti is crazy as a fox.
Yeah, absolutely. Well, it's one of those things too. It's like, how was he crazy the month before the murders, right?
Yeah. And I mean, his wife had left him with his daughter. He was not in agreement with the way the custody case was being handled. He was probably not in agreement with, there was, I think, an underlying support issue as well. She had gone to live with her parents. He went to her parents' house. He broke in her parents' house. He shot and killed her parents in front of her and his 3-year-old daughter that he claims he loves so fucking much. This child is going to have a horrendous life and problems like you would not believe because of what her father did in front of her to her grandparents and her mother and her, because he held her and her mother hostage at gunpoint in a standoff with police for several hours after murdering her grandparents in front of her and her mother. So, and even at 3 years old, I think that probably if we talk to her, we don't know her. I don't know her name. I haven't looked for her name, but I bet if we talk to her, she would probably have, some consequences of her father's actions to relay that she has had to deal with and live with.
Yeah.
Since 1992.
No, for sure.
So, and this is where I kind of, it proves what little man he is, because instead of just taking the consequences, he's trying to escape culpability by saying he's crazy and acting crazy. Petitioner prisoner sought a writ of habeas corpus, arguing inter alia that his mental condition barred his execution. The United States Court of Appeals for the Fifth Circuit affirmed the district court's denial of the petition on the ground that its test for competency to be executed required the prisoner to know no more than the fact of his impending execution and the factual predicate for the execution. A writ of certiorari was granted. Jurisdiction to adjudicate the prisoner's claims was proper, even though it was the second application, as the 28 USC 2244 limit on second or successive petitions did not govern where a 28 USC 2254 application raising a Ford incompetency claim was filed as soon as the claim was ripe. Review was without deference, as the state court's failure to provide procedures mandated by case law after the prisoner made a substantial showing of incompetency was an unreasonable application of clearly established case law. The state court failed to provide the prisoner with the required minimum process where it conveyed untrue information to counsel, provided an inadequate opportunity to submit expert evidence in response to a report filed by court-appointed experts, and made its determination without holding a final competency hearing. The prisoner's severe delusions could have rendered him incompetent to be executed, even though he could identify the stated reason for his execution. Thus, the prisoner's submission that his documented delusions prevented him from comprehending the meaning and purpose of the punishment to which he had been sentenced should have been considered. The judgment was reversed. The case was remanded to allow the district court the initial opportunity to resolve the prisoner's Eighth Amendment claim. And that decision was rendered on June 28, 2007. Again, quite a long holding. I'm not going to go into it. It's multiple pages and multiple subparts. And what it basically comes down to is that they don't like the state court procedures in Texas, and they don't like the way the federal court oversaw those procedures, and so they're making them do it all over again. The majority opinion was authored by Justice Kennedy. It was a per curiam opinion joined by Justices Stevens, Souter, Ginsburg, and Breyer. Justice Thomas, joined by Chief Justice Roberts, Justice Scalia, and Justice Alito, authored a dissent. And they expressed the view that because neither AEDPA's text pre-AEDPA precedent nor our AEDPA jurisprudence supports the court's understanding of second or successive, the court falls back on judicial economy considerations. The court suggests that my interpretation of the statute would create an incentive for every prisoner, regardless of his mental state, to raise and preserve a Ford claim in the event the prisoner later becomes insane. Even if this comes to pass, it would not be the catastrophe the court suggests. District courts could simply dismiss unripe Ford claims outright, and habeas applicants could then raise them in subsequent petitions under the safe harbor established by Martinez Villarreal. Requiring the Ford claims be included in an initial habeas application would have the added benefit of putting a state on notice that a prisoner intends to challenge his or her competency to be executed. In any event, regardless of whether the court's concern is justified, judicial economy considerations cannot overrule AEDPA's plain meaning. Remaining faithful to AEDPA's mandate, I would dismiss Panetti's application as second or successive, and that the court also erred in holding that the state court unreasonably applied clearly established Supreme Court precedent by failing to afford Panetti adequate procedural protections. Panetti is entitled to habeas relief only if the state court proceedings resulted in a decision that was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States. Even if Justice Powell's concurrence in Ford qualifies as clearly established federal law on this point, the state court did not unreasonably apply Ford. So on remand in March 26, 2008, the U.S. District Court held that Panetti's deranged mental state may wax and wane, but it is continued to a significant degree throughout his incarceration and continues today. While the extent to which Panetti has been manipulating or exaggerating his symptoms is unclear, it is not seriously disputable that Panetti suffers from paranoid delusions of some type, and these delusions may well have contributed to his murder of Joe and Amanda Alvarado. However, it is equally apparent from his recorded conversations with his parents that these delusions do not prevent him from having both a factual and rational understanding that he committed those murders, was tried and convicted, and is sentenced to die for them. Furthermore, his delusions do not prevent his rational understanding of the causal connection between those murders and his death sentence, and he in fact has such an understanding. Panetti's understanding of the causal connection between his crime and his punishment is most clearly demonstrated by his rationally articulated position that the punishment is unjustified. He believes the state should not execute him because he was mentally ill when he committed the murders. This position is based on and necessarily indicates a rational understanding that the state intends to execute him because he committed the murders. Panetti was mentally ill when he committed this crime and continues to be mentally ill today. However, he has both a factual and rational understanding of his crime, his impending death, and the causal retributive connection between the two. Therefore, if any mentally ill person is competent to be executed for his crimes, this record establishes it is Scott Panetti. In accordance with the foregoing, it's ordered that Panetti's petition for writ of habeas corpus is denied. It's further ordered that the execution of Scott Lewis Panetti shall be stayed pending the outcome of the appeal in this case, signed the 26th day of March, 2008. So he had been apparently, even before that, he had been given a new execution date. So I guess he returned to state court and they found him competent to be executed and they gave him a new execution date. Again, we'll look at the case in detail, and things that I probably missed in my research will come to pass. On December 17, 2008, the Fifth Circuit ordered that appellant's motion to stay and abate proceedings to return to state court to raise a claim based on the Supreme Court's groundbreaking decision in Indiana versus Edwards was granted. So this is another case that I didn't look at because I didn't find out about it until well into my note-making process. On August 21st, 2013, the Fifth Circuit Court of Appeals issued its opinion in Panetti versus Stevens, 727 Federal 3rd, 398. The district court's determination that petitioner who was convicted of capital murder was competent to be executed under the Eighth Amendment was not clearly erroneous because petitioner had both a factual and rational understanding of his crime, his impending death, and the causal retributive connection between the two, and petitioner's understanding was clearly demonstrated by his rationally articulated position that his punishment was morally unjustified in light of his insanity at the time of his offense. A new rule of law holding that states had discretion to insist upon representation by counsel for those competent enough to stand trial, but who still suffered from severe mental illness, was not retroactively applicable on collateral review because the new rule did not alter the bedrock procedural elements essential to the fairness of a proceeding. The court affirmed the district court's denial of habeas corpus, and on November 26, 2014, the U.S. District Court ordered that his motion for stay of execution be denied, that his corrected motion for authorization of funds was denied, to hire mental health expert and investigator, and that his motion for appointment of counsel was denied. That was 2014. December 3rd, the federal appellate court, the Fifth Circuit, stayed the execution pending further order of the court to allow us to fully consider the late arriving and complex legal questions at issue in this matter. An order setting a briefing schedule and oral argument will follow. And then on July 11, 2017, they handed down their opinion in Panetti versus Davis, 863 F. 3rd, 366. Petitioner's counsel learned on October 30th, 2014, that petitioner's date of execution was December 3rd, 2014. Given that in Texas in 2014, no notice was required to be given to capital defendants or counsel when execution was set. Counsel filed a motion and asked that the execution date be modified to allow time to pursue the issue of petitioner's competency, which was denied. The application of Article 46.05 to petitioner denied him due process. He was entitled to pursue his federal habeas claim, and its denial was error. And other investigative resources under 18 USC 3599F, given that a decade had passed since the last determination of whether petitioner, who was conceitedly mentally ill, was competent to be executed. So they reversed the judgment, the findings were vacated, and the case was remanded. And, paranoid schizophrenics can be some of the meanest motherfuckers on the planet. And they are not necessarily mentally ill in the sense that they don't know right from wrong and that they can't conform their conduct. And that's a challenge for mental illness.
Yeah.
If you don't know right from wrong, I mean, if he said that his in-laws and his ex-wife and his child were all aliens, lizard people trying to kill him, and that's why he went to their house. I mean, he can't say that. He went to their house. He broke into their house. He can't say that they were lizard people trying to kill him because he went to them. It's kind of
Right.
like Jodi Arias trying to claim self-defense when she drove 12 hours
Yeah.
from California, from Northern California to Arizona to kill Travis Alexander. He was a man on a mission. He was wearing camouflage clothing. So anyway, as you see in the notes, there was an evidentiary hearing in 2022, October 24th to October 26th. And I did not find an order or an opinion rendered on that hearing. There was a lot of briefing, but there's been no opinion or order since that hearing. So I guess maybe the federal judge is just waiting for Scott Panetti to die of natural causes, because he's probably my age or a little bit older than I am. So next case is Kennedy versus Louisiana. And this was this crime occurred on March 2nd, 1998. It involved the first-degree rape of a child under 12. It occurred in Harvey, Louisiana, and was tried in the 24th Judicial District Court for the parish of Jefferson, state of Louisiana. The victim was L.H., who was Kennedy's 8-year-old stepdaughter. The perpetrator was Patrick Kennedy, the defendant. He had a prior sexual abuse and sexual assault against a daughter of a cousin during an unknown time frame when that child was 8 years old. But the facts of that were not particularly well developed in his direct appeal, only that was a factor, an aggravating factor that led to him being sentenced to death. He was convicted. He was arrested March 10th, 1998 by the Jefferson Parish Sheriff's Office. Basically, what he claimed is that 2 black teenage boys raped his stepdaughter outside the house. Prior to phoning the police, he phoned his boss and said he wouldn't be in. And then he phoned a carpet cleaning company to ask them how to get blood out of a carpet. This child
really smart.
was severely injured. Patrick was quite a large man, and it probably was not his genitalia that was specifically large. It was him. He was a big guy. And this was an 8-year-old child. He severely injured her. He tried to lie to the police. He tried to get her to lie to the police. It fell apart. And police realized that what he was claiming happened, there was no evidence of anything where he claimed the rape happened, the ground wasn't disturbed. There was no blood. There was no bike tracks. There was no sign that anybody had been there in days. And there were signs of something happening in the child's bedroom. So that's why he got caught, because he was, instead of saying, I caught them in the house, in her room, he tried to put the crime out of the house. I guess he thought he would give them no reason to come in the house. He was convicted on August 8th, 2003, and sentenced to death, probably around August 25th, 2003. This was a rape. The child did not die. This was a rape of a child under 12.
Oh, God.
He appealed to the state court, the Supreme Court of Louisiana. Petitioner, a Louisiana prisoner who was sentenced to death, sought certiorari review of a judgment from the Supreme Court of Louisiana, which upheld his capital sentence following his conviction under Louisiana Revised Statute annotated Section 14:42, 1997, and Supplement 1998 for the aggravated rape of an 8-year-old child. The Supreme Court of Louisiana rejected petitioners' argument that the death penalty for the rape of a child under 12 was disproportionate, and it upheld the constitutionality of the statute under the Eighth Amendment. The court, however, held that the Eighth Amendment barred respondent, the state of Louisiana, from imposing the death penalty on petitioner. Based both on consensus and its own independent judgment, the court held that a death sentence for one who raped but did not kill a child and who did not intend to assist another in killing the child was unconstitutional under U.S. Constitutional Amendments 8 and 14. After reviewing the history of the death penalty for the crime of child rape, current state statutes and new enactments, and the number of executions since 1964, the court concluded that there was a national consensus against capital punishment for the crime of child rape. The court also concluded that its independent judgment that the death penalty was not a proportional punishment for the crime of child rape. The court found that its decision was consistent with the justification offered for the death penalty, retribution, and deterrence. The court reversed the judgment and remanded the case for further proceedings, not inconsistent with the court's opinion. 5-4 decision, 1 dissent. Interestingly, I think another state, it might be Oklahoma, has passed a similar statute. Apropos of nothing. Their decision was handed down on June 25th, 2008. They reversed and remanded. And they basically held the Eighth Amendment barred Louisiana from imposing the death penalty for the rape of a child where the crime did not result and was not intended to result in the victim's death. And then there's a lot of, again, sociological and extrajudicial rationalizations for why this is not right in the court's eyes, et cetera, et cetera. Which I don't think a single thing of it was ever proven to exist by Kennedy, but okay. So that's, I mean, look at the number of pages. Like goes from page 53 to 58 or 57 rather. Like a lot of moral justifications for their decision and not really looking at the reality or why the Louisiana legislature enacted the statute in the fucking first place. Justice Kennedy authored the majority opinion, joined by Justices Stevens, Souter, Ginsburg, and Breyer. Justice Alito authored a dissent, joined by Chief Justice Roberts, Scalia, and Thomas. They all expressed the view that the majority's holding the Eighth Amendment categorically prohibits the imposition of the death penalty for the crime of raping a child, no matter how young the child, no matter how many times the child is raped, no matter how many children the perpetrator rapes, no matter how sadistic the crime, no matter how much physical or psychological trauma is inflicted, and no matter how heinous the perpetrator's prior criminal record may be. The court provides 2 reasons for this sweeping conclusion. First, the court claims to have identified a national consensus that the death penalty is never acceptable for the rape of a child. Second, the court concludes, based on its independent judgment, that imposing the death penalty for child rape is inconsistent with the evolving standards of decency that mark the progress of a maturing society. Neither of these justifications is sound. Totally agree. This crime put the child in a hospital with severe bleeding. Although it's not disclosed, she probably could not have children.
Oh God, yeah, this is horrible.
So the effects are more than just an unpleasant experience for her. This has lifelong consequences for her.
Yeah, physical and psychological.
So the statute had to be, it was held unconstitutional. Kennedy was resentenced on January 7th, 2009 to life imprisonment without benefit of parole, probation, or suspension of sentence. And he remains incarcerated in Louisiana State Penitentiary at Angola to this day.
And at least that's a pretty rough place.
Yeah, it is a pretty rough place, although he's a predator.
Yeah.
So I would imagine that anybody small, young, has probably been subjected to his, because, he's got the one child that came forward. She was probably a teenager by this time. But who knows how many other children.
Yeah.
And that's another thing. And that's one of the reasons that this was enacted, is because for these child predators, the recidivism rate is frightening. I mean, they'll enter a plea, they'll do a few years, they'll come out. Even though they report, they still do it again and again and again and again.
Yeah.
And that's why the legislature decided to enact a death penalty. And that's why this other state, possibly Oklahoma, has enacted a similar statute, which unfortunately probably will not stand the test of constitutional challenge subjected to the U.S. Supreme Court. But hopefully we'll see. Next case is the District Attorney's Office for the 3rd Judicial District versus Osborne, 557 U.S. 52, decided in 2009. This case arises from the March 22nd, 1993 kidnapping, first-degree sexual assault, and first-degree assault, or 2 counts of sexual assault and first-degree assault against a woman known by the initials KG, who was a sex worker in Anchorage, Alaska. It was tried in Superior Court, 3rd Judicial District in Anchorage, whatever county in Alaska that may be, and also the U.S. District Court for the District of Alaska. The defendant is William Osborne, and his accomplice was Dexter C. Jackson. He was arrested in Fort Richardson, Alaska on March 28, 1993. He was tried in March of 94. He was convicted and sentenced to 26 years with 5 years suspended. He basically sought DNA testing in federal court, and the appeal is by the District Attorney's Office from a decision of the Ninth Circuit Court of Appeal. Respondent state inmate filed an action under 42 USCS 1983, claiming that he had a constitutional right to have access to evidence that was introduced at his trial so he could have DNA testing conducted at his expense. The U.S. District Court for the District of Alaska ordered Petitioner District Attorney's Office to give the inmate access, and the U.S. Court of Appeals for the Ninth Circuit affirmed. Petitioner sought further review. Thank God. And this is the case that spurred Hank Skinner versus Switzer.
Oh,
it's
yeah.
the case that spurred Rodney Reed versus Brian Gertz. Which I haven't checked on that one at the Fifth Circuit. I'll have to check on that. The inmate and another person were convicted of kidnapping, assault, and sexual assault after they first forced a prostitute to perform fellatio and sexual intercourse and choked her, beat her, and shot her when she tried to flee. The inmate sought post-conviction relief in an Alaska court, claiming that he received ineffective assistance counsel because his counsel did not seek restriction, fragment length, polymorphism, DNA testing on sperm found in a condom at the scene of the crime. However, the state court denied relief. After the state court denied relief, the inmate filed an action in federal district court seeking an order requiring an Alaska District Attorney's Office to give him access to evidence that was introduced at his trial so he could have DNA tests conducted at his expense. And this was claiming a constitutional right to access to this evidence to exonerate himself. which is the argument that they always make. The U.S. Supreme Court held that the Court of Appeals erred when it found that the inmate had a right under the Due Process Clause of the 14th Amendment to have access to the evidence he sought. The issue of access to DNA evidence post-conviction was best left to Congress and state legislatures, and there was nothing inadequate about the procedures Alaska provided to inmates. The Supreme Court reversed the Court of Appeals judgment and remanded the case for further proceedings. It was a 5-4 decision, 1 concurring opinion, 2 dissents. June 18, 2009, it was reversed and remanded. And I think what Skinner was attempting to do was to do better than Osborne and establish a constitutional right, which
That makes sense.
he didn't do, because he ended up, when the state agreed to permit the testing he wanted, he dropped his claim. So it may be Rodney Reed's case that ends up once again saying no constitutional due process right, because Bastrop is not going to permit the testing he wants. So now they're going to let Texas is going to let their procedures be evaluated by the court. So the reverse and remand, the holding was that assuming Osborne's claims can be pursued using Section 1983, he has no constitutional right to obtain post-conviction access to the state's evidence for DNA testing. And this is for a very good reason, and this is why I'm going to go ahead and go through each of the subparts of the holding, because it builds upon the next. DNA testing has an unparalleled ability both to exonerate the wrongly convicted and to identify the guilty. The availability of new DNA testing technologies, however, cannot mean that every criminal conviction, or even every criminal conviction involving biological evidence, is suddenly in doubt. The task of establishing rules to harness DNA's power to prove innocence without unnecessarily overthrowing the established criminal justice system belongs primarily to the legislature. See Washington versus Glucksberg. 46 states of the federal government have already enacted statutes dealing specifically with access to evidence for DNA testing. These laws recognize the value of DNA testing, but also the need for conditions on accessing the state's evidence. Alaska is one of a handful of states yet to enact specific DNA testing legislation, but Alaska courts are addressing how to apply existing discovery and post-conviction relief laws to this novel technology. The court assumes without deciding that the Ninth Circuit was correct that Heck does not bar Osborne's 1983 claim. That claim can be rejected without resolving the proper application of Heck. The Ninth Circuit erred in finding a due process violation. While Osborne does have a liberty interest in pursuing the post-conviction relief granted by the state, the Ninth Circuit erred in extending the Brady right of pretrial disclosure to the post-conviction context. Osborne has already been found guilty and therefore has only a limited liberty interest in post-conviction relief. See Herrera versus Collins. Instead of the Brady inquiry, the question is whether consideration of Osborne's claim within the framework of the state's post-conviction relief procedures offends some fundamental principle of justice or transgresses any recognized principle of fundamental fairness in operation. And that cites to a case, Medina versus California. Federal courts may upset a state's post-conviction relief procedures only if they are fundamentally inadequate to vindicate the substantive rights provided. There is nothing inadequate about Alaska's post-conviction relief procedures in general, or its methods for applying those procedures to persons seeking access to evidence for DNA testing. The state provides a substantive right to be released on a sufficiently compelling showing of new evidence that establishes innocence. It also provides for discovery in post-conviction proceedings and has, through judicial decision, specified that such discovery is available to those seeking access to evidence for DNA testing. These procedures are similar to those provided by federal law and the laws of other states, and they satisfy due process. The same is true for Osborne's reliance on a claimed federal right to be released upon proof of actual innocence. Even assuming such a right exists, which the court has not decided and does not decide, there is no due process problem given the procedures available to access evidence for DNA testing. The court rejects Osborne's invitation to recognize a freestanding substantive due process right to DNA evidence, untethered from the liberty interests he hopes to vindicate with it. In the circumstances of this case, there is no such right. Generally, the court is reluctant to expand the concept of substantive due process because guideposts for responsible decision-making in this uncharted area are scarce and open-ended. And that cites to Collins versus Harker Heights. There is no long history of a right of access to state evidence for DNA testing that might prove innocence. The mere novelty of such a claim is reason enough to doubt that substantive due process sustains it. And that cites Reno versus Flores. Moreover, to suddenly constitutionalize this area would short circuit what has been a prompt and considered legislative response by Congress and the states. It would shift to the federal judiciary responsible for devising rules governing DNA access and creating a new constitutional code of procedures to answer the myriad questions that would arise. There is no reason to suppose that federal courts' answers to those questions will be any better than those of state courts and legislatures, and good reason to suspect the opposite. And that cites to Collins Supra. So the majority opinion was authored by Chief Justice Roberts. He was joined by Justice Scalia, Kennedy, Thomas, and Alito. Justice Alito also authored a concurrence joined by Justice Kennedy and Thomas as to Part 2. And I'm not going to go into all the reasoning on those. Justice Stevens authored a dissent joined by Justices Ginsburg, Breyer, and Souter as to Part 1, expressing the view that the state of Alaska possesses physical evidence that, if tested, will conclusively establish whether respondent William Osborne committed rape and attempted murder. If he did, justice has been served by his conviction and sentence. If not, Osborne has needlessly spent decades behind bars while the true culprit has not been brought to justice. The DNA test Osborne seeks is a simple one, its cost modest, and its results uniquely precise. Yet for reasons the state has been unable to or unwilling to articulate, it refuses to allow Osborne to test the evidence at his own expense and to thereby ascertain the truth once and for all. Well, here it is. This is the argument. This is the one that they're using in Eccles. Well, why won't this, if they're so sure, why won't they test it? And the problem is that it's not necessarily going to answer the questions, and it's not necessarily going to be conclusive. And it's also dangerous to let somebody have access to evidence and to pay for it and let them control the results. Because we see from Eccles that they're not necessarily going to be honest about those results.
Yeah, no, absolutely.
So, and they go on to say that on two equally problematic grounds, the court today blesses the state's arbitrary denial of the evidence Osborne seeks. First, while acknowledging that Osborne may have a due process right to access the evidence under Alaska's post-conviction procedures, the court concludes that Osborne has not yet availed himself of all possible avenues for relief in state court. As both a legal and factual matter, that conclusion is highly suspect. More troubling still, based on a fundamental mischaracterization of the right to liberty that Osborne seeks to vindicate, the court refuses to acknowledge in the circumstances of this case any right to access the evidence that is grounded in the due process clause itself. Because I am convinced that Osborne has a constitutional right of access to the evidence he wishes to test, and that on the facts of this case, he has made a sufficient showing of entitlement to that evidence, I would affirm the decision of the Court of Appeals. Excuse me. Souter also authored a dissent expressing the view that while the inadequacy of each of the state's reasons for denying Osborne access to the DNA evidence he seeks would not make out a due process violation, taken as a whole, the record demonstrates that while Alaska has created an entitlement of access to DNA evidence under conditions that are facially reasonable, the state has demonstrated a combination of inattentiveness and intransigence in applying those conditions that add up to procedural unfairness that violates the due process. Okay, well, the court didn't agree because the court found that their procedures were entirely adequate. So, anyway, okay, let's move on. And this is, I think, our last case for this round
Session.
of
Right.
U.S. Supreme Court review. Graham versus Florida, 560 U.S. 48, 2010. The case arose from an armed burglary, assault, and attempted robbery that occurred in July 2003 in Jacksonville, Florida. It's unknown. The identity of the victim or victims is unknown. The perpetrator was Terrence Jamar Graham. He was 16. This was a home invasion. Or actually, no. He was 16. He was caught because on December 2nd, 2004, he was arrested after participating in a home invasion. He was tried on... Oh, wait. Okay. He entered a guilty plea on December 28, 2003. Apparently, he got a suspended sentence and he participated in a home invasion on December 2nd, 2004. This arises from the District Court of Appeal of Florida, 1st District. Okay, sorry for the confusion. While he was a juvenile, although charged as an adult, defendant pleaded guilty to armed burglary with assault and attempted robbery, was adjudicated guilty after violating conditions of probation, and received the maximum sentence of life imprisonment without parole. Upon the grant of a writ of certiorari, the defendant appealed the judgment of the 1st District Court of Appeal of Florida, which affirmed the defendant's sentence. The defendant contended that, as a juvenile who did not commit or intend to commit homicide, the sentence of life imprisonment without parole constituted cruel and unusual punishment. The U.S. Supreme Court held that the Eighth Amendment prohibited the imposition of a life without parole sentence on the juvenile offender who committed a non-homicide crime, and while the defendant need not be guaranteed eventual release from the life sentence, he must have some realistic opportunity to obtain release before the end of his life term. The practice of sentencing a juvenile who did not commit a homicide offense to life without parole was exceedingly rare, and a national community consensus developed against it, and none of the recognized goals of penal sanctions, i.e., an retribution, deterrence, incapacitation, or rehabilitation, provided an adequate justification for the sentence. Further, it could not be conclusively determined at the time of sentencing that the juvenile defendant was a danger to society for the rest of his life, and a sentence of life without parole improperly denied the juvenile offender a chance to demonstrate growth, maturity, and rehabilitation. The judgment affirming the defendant's sentence was reversed, and the case was remanded for further proceedings. It was a 6-3 decision, 2 concurrences, and 2 dissents. Now, what I want to point out is that apparently, after his guilty plea and receiving probation, he engaged in a home invasion, a notoriously dangerous and violent crime, which usually does end in the death of at least a perpetrator or a victim.
Right. Yeah, absolutely.
So I would suggest that the life sentence without possibility of parole was because that's the type of crime that he was being
Right.
violated for. But this only dealt with this. Actually, really only dealt with mandatory life sentences, whereas, attempted murder, mandatory life sentence, murder, mandatory life sentence, armed robbery, mandatory life sentence. If there was a range of punishment and if there was discretion for the trier of fact or the judge to consider the youth and the lack of development or whatever, then you could sentence a juvenile to life without the possibility of parole. If you were taking multiple factors into account. And these were basically, it was a mandatory sentence. The judge didn't have any discretion. So on July 6, 2010, it was reversed and remanded. And basically the holding was that the clause does not permit a juvenile offender to be sentenced to life in prison without parole for a non-homicide crime. And again, this is another holding that goes into societal, sociological, psychological, developmental mumbo jumbo, at least as I see it. I mean, it goes from page 64 to 68.
I mean, it's basically the same thing we said earlier.
And it's
the
all
logic that they just shouldn't be convicted of anything.
Well, no, it's that they shouldn't be punished.
Well, yeah, fair enough. They shouldn't be punished
as harshly as though they were an adult. Now, again, if he'd been 18, they could have sentenced him to life without the possibility of parole under a mandatory sentence, even for a non-homicide crime. But because he's a kid, a juvenile, he gets a pass. And this is one of the problems that I have as well with some of these juvenile things. If you have got a kid who's not minding mom and dad, not at home, not going to school, doing what he wants to do, when he wants to do it, how he wants to do it, despite the best efforts of his family and peers and siblings, then if he ends up committing a crime that puts him in prison for the rest of his life, that's on him. He wanted to act like he was grown. Let him suffer like he was grown. Because that's a lot of the problem with a lot of juvenile crime is these kids are out, sneaking out of the house or lying to their parents and going where they're not supposed to be. And it happens equally in, black on black crime where these kids are getting shot to death by other kids in rival gangs and rival gang activity and drug dealing. But most of the time it's because they were where they weren't supposed to be after having lied to mom and dad or just ignoring mom and dad saying, stop doing this. So, and I wish the court and the sociologists and the psychologists and the criminal justice people would look at that aspect and say, let's solve that problem. Let's encourage these kids to do what their parents want them to do. Because some of these kids come from relatively good homes and the parents aren't engaging in criminal activity. They're not learning this at home. They're learning this on the streets because they want to act like they've grown. Well, if they want to act like they're grown, then they need to suffer the consequences like they were grown.
Right.
All right. So the majority was authored by Justice Kennedy, joined by Justices Stevens, Ginsburg, Breyer, and Sotomayor. Justice Stevens, joined by Ginsburg and Sotomayor, authored a concurrence. I'm not really going to go on into that. Justice Roberts also authored a concurrence. But he also felt there was no need to invent a new constitutional rule of dubious provenance in reaching that conclusion. Instead, based on an application of this court's precedents, in particular, are cases requiring narrow proportionality review of non-capital sentences, and our conclusion in Roper versus Simmons that juvenile offenders are generally less culpable than adults who commit the same crimes. Justice Thomas authored a dissent joined by Justices Scalia and Alito in parts 1 and 2, expressing the view that the members of this court are any more capable of making such moral judgments than our fellow citizens. Nothing in our training as judges qualifies us for that task, and nothing in Article 3 gives us that authority. Justice Alito also authored a dissent, expressing the view that the court holds only that for a juvenile offender who did not commit homicide, the Eighth Amendment forbids the sentence of life without parole. Nothing in the court's opinion affects the imposition of a sentence to a term of years without the possibility of parole. Indeed, petitioner conceded at oral argument that a sentence of as much as 40 years without the possibility of parole probably would be constitutional. Justice Thomas also, this is still Justice Alito. The question whether petitioner's sentence violates the narrow as-applied proportionality principle that applies to non-capital sentences is not properly before us in this case. Although petitioner asserted as-applied proportionality challenge to his sentence before the Florida courts, he did not include an as-applied claim in his petition for certiorari or in his merits brief before this court. Indeed, Instead, it's dark in here. Petitioner argued for only a categorical rule banning the imposition of life without parole on any juvenile convicted of a non-homicide offense. Because petitioner abandoned his as-applied claim, I would not reach that issue. And then he referred to case law and a case called Yee versus Escondido. So that's the end. And I just got a unstable message, so I think it's probably best to wrap this up while I still have internet.
Yeah, no, it sounds good. Well, another great episode. Thanks for all your work.
Our Supreme Court review. I'm going to put Graham as another case to look at, because I'll bet you given time and resources, I can find a lot more information about Terrence Jamar Graham than I did in the brief time that I had.
I got it.
Because this was another one that was like, I had started my notes. I came across the site in another case, and then I added this one to my pile. So, and bit off more than I could chew. So we actually didn't get to Martinez Trevino because those happened after 2010. So we're gonna look at cases I missed prior to 2010, and then the cases after 2010 in season 3.
Hey, so Lisa, I think we're losing you.
Yeah, okay. All right. Well, let me go ahead and do my outro, and then we'll call it a day. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Rob Chadwick. Oh, I'm sorry, Kyle Evans. That's what I get for using an old form. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I will return in 2 weeks for episode 14, State of New York versus Ronald Joseph DeFeo Jr., and the alleged Amityville horror at 112 Ocean Avenue. We'll talk about the murders of Ronald Sr., Louise, Dawn, Allison, Mark, and John Matthew, DeFeo's changing stories, his trial and conviction, and the claims made by George and Kathy Lutz in 1975, which resulted in the book The Amityville Horror by author Jay Anson. Until then, have a great 2 weeks and stay safe.